ChatGPT is not your lawyer. My name is Paige Sparks. I'm a lawyer, and if you haven't been convinced so far to not use ChatGPT or AI as your free lawyer, here's another horror story for you. A federal court recently ruled that AI-generated documents through Claude were not privileged, and they were fair game to be used against the guy that made them. Here's what happened. The U.S. Department of Justice brought criminal charges against Bradley Heppner for securities fraud, wire fraud, and other related offenses. He's the founder of a financial services company called Beneficient. These charges stem from allegations that Heppner was defrauding investors by misrepresenting that a third-party lender was a third-party lender when it was actually just an entity controlled by Heppner. When he was charged, federal agents arrested him and they confiscated all of his electronic devices in his home, and they seized about 31 documents that he had used Claude, artificial intelligence, to analyze defenses he can use in his case and prepare other legal documents analyzing the government's position, bringing the charges against him. This is an ongoing criminal case, and his criminal defense attorneys have alleged that these documents should not be given to the other side, or they shouldn't be fair use because of confidentiality and the work product doctrine. The work product doctrine, or the work product privilege as it's also known, is a legal protection that shields the other side from getting things that you prepare in anticipation of litigation or at the direction of an attorney or an attorney's own work product that might reveal strategy for trial, for example. This doctrine can apply to any representative of a party that prepared something for litigation. So it can apply to attorneys, representatives, insurance, or agents. So they were trying to say this also extended to Claude. The problem for Heppner is he prepared these documents on his own before he had these lawyers. So sharing non-privileged information with a lawyer does not make it privileged. They also didn't direct him to do that. So really no privilege applied. The government proactively sought an order for the court to determine that AI did not create privileged or confidential documents and was not an attorney. Therefore, all those documents that were seized were fair game to use in the prosecution of Heppner. The government also argued that third-party platforms that present this AI feature have no duty of confidentiality to the users or loyalty from disclosing that information. And in the normal world, if I write a letter to my client and they show it to their cousin, that waives the privilege. So they were saying that kind of concept applied. When you share something with a third party that has no privilege, it doesn't make it a privileged document. The judge agreed with the government and said that any documents that were prepared by the generative AI were not privileged and none of the protections from the doctrine applied. Here's why it's a big deal for you if you are DIYing a legal situation with ChatGPT or some other form of AI. This decision is going to be used to argue that privilege does not apply to anything you put in or get out of AI because it's a third-party platform. The same thing applies as if you put your deepest, darkest concerns and secrets about your lawsuit in ChatGPT to talk through it and tell you what you think. They can request that information and literally see your cards. Whenever I do a specific topic on AI as your lawyer, there are some common comments I get that I want to address. First of all, this is not about job security for me or any lawyer. We will always have a job. This is literally about people using an AI attorney shooting themselves in the foot because you're going to show all of your playing cards to the other side. They're going to get all that information, all those communications. It has nothing to do with job security. This is purely a confidentiality and privilege issue. I also see a lot of people comment say, well, I just won't admit that I use it, or I'll deny that I have it, or I won't produce that information or correspondence. Well, that can get you in even bigger trouble if you lie and say it doesn't exist and it does, or you refuse to produce it and it's fair game and you should have. You can be subject to things like sanctions or other punishments if you go down that route. If you get a request for production for your ChatGPT account and all the stuff you've put in there and you say it doesn't exist and they send a subpoena to ChatGPT and find it does exist because it's related to your IP address or your account or whatever, now you're in even hotter water. And let me just tell you, waiving privilege is probably the least of your concerns because you got caught in a lie. Do what you want with this information. I'm just trying to help. If you are going to continue to use ChatGPT for your legal things, at the bare minimum, disclose it to your lawyer so we aren't blindsided later.